Well, we're back talking about the Dobbs case and
Woof, woof,
Roe
woof, woof.
versus Wade.
You have to do the introduction. You're still
Part
so excited about
two.
this case.
This is part 2 of our episode, Parallel Barking. You know who we are.
Yeah, well, yeah. And I've been trying to make Ariana feel better about the case.
It's not working.
It's not working, but we are finding all kinds of interesting things that are going on. We haven't really talked about two things. One is the actual substance of the decision, and the other is the leak itself. And maybe for the second part of the podcast, we can talk about those two.
Okay. So the substance of the draft decision.
Yes.
Okay.
Yes.
Okay. So parts of it I just thought were interesting. That, I mean, well, I actually want to hear your take because you're the lawyer, you're the constitutional law expert.
No.
Yes.
Remember, I'm an outlier here. The American academic constitutional aristocracy and I don't often see eye to eye.
That doesn't matter.
All right. Well, you're not going to get the orthodox view, and what we have are two orthodoxies here: that of the majority and that of likely a very powerful set of dissenting opinions. And there's a lot to dissent from in this case. One of them being of course, the Roe case. So let's talk about the substance. Everyone has known for a long time that the underlying nature of Roe was jittery. And there hasn't been very many people who continue to defend Roe full on. The same, and this is what is really scary, and some people have begun talking about this, the same can be said for Brown versus Board of Education and the foundational case that brought us to what hopefully is a much more enlightened state of relations among race, ethnic, and religious groups in this country, but mostly racial groups in this country. But the underlying basis for the decision is eminently one can eminently engage with it. I'm trying to be tactful. And we've all known this. Virtually, there hasn't been a single confirmation hearing where someone doesn't say, well, I have my qualms about even the supporters of a constitutionalization of women's autonomy, right? In the context of terminations of pregnancy. They've all said, well, yeah, I got a quibble here and a quibble there.
It's so bizarre. I mean, think about that. Can you say that out loud again?
Right.
I don't want to allow women to have their own autonomy.
Well,
no. Well, in consultation with a doctor.
All right, but here's a question for you. And I've come to think about this more and more. And this is a kind of radical position, I suspect. Why is it that women, in this case, because we're dealing with an issue of fundamental importance to women. So I'm focusing on women here, but it applies to everyone. But in this context, it's women in specifically. Why is it that they need someone's permission to take their own autonomy for themselves?
We need that protection because obviously people are trying to take it away. That's why. Yes,
some people are trying to take it away, but we have an open political system here. This is worrisome. If in fact what the decision says is that we're throwing this back into politics, then this is a moment for women to, again, in our last podcast, we ended by talking a little bit about solidarity. This may be the moment of solidarity for women as well. But the issue here, right, with respect to the substance of the opinion, which is where we were going, was, well, it's the decision, just like the Roe versus Wade decision, technically has been open to question for a long time. And certainly the legal academy, whether you supported the result or not, everyone has had a field day with this case the way they've had a field day with Brown. No one wanted to touch the result, but everyone had a go at the reasoning, right? And so you've developed, and in a sense, the critical people in both instances really did a tremendous job of undermining popular conceptions of the legitimacy of the result by constantly going and doing their academic BS on, and quite rightly, I say academic BS, and of course my academic colleagues are going to go, oh my God, you should be expelled from the academy.
Because it is BS, because
heresy.
you called it.
No, but BS not in the sense that their critique is wrong, but BS in the sense that what they were doing advertently or inadvertently were conflating what, and here again another perversity, their effort, like Alito's, to find the perfect set of justification, again, the search for perfection, right? But in the process of the search for perfection in the support for the result, then produces a counter search for perfection that then undermines, by in its search, the result itself.
The result, yeah.
Right. And so this is a setup that's been 50 years in the making, and everyone has had a hand in this. Everyone has had a hand in this. And in a sense, we start from a contextually, people forget what the 70s, the early 70s were like. This was the heady days when it was the conservatives who tended to view the court as increasingly illegitimate because they were increasingly following a very specific political ideology. Now the shoe is on the other foot, and it's the liberals, so-called liberals, I don't know what these things mean anymore, who now view the court as illegitimate only because the justices are no longer aligned politically with their view. It
With
just
their views.
shows you how these things are fungible. But at the time, the decision, and it was a time when we still sort of believed in the value of scientific reasoning, that in fact, if we can use logic and the value of science, especially the social sciences, that somehow that would be a much greater justification than silly old normative rules and principles. And so there was this arc of underlying determination that if you really truly want this decision to sound and be perfect, and again, this is both sides, the left and the right here are both seeking perfection, which is just so profoundly bizarre, that they decided that, well, we can't really rely on jurisprudence anymore, because how can you rely on that for perfection? We have to rely on something harder. And what could be harder than the social sciences? At this point, I'm laughing internally. I'm laughing hysterically internally at this notion, but the notion stuck. Especially for lawyers, which is another perversity and irony. And so everyone loved going to the social sciences and getting data. There's nothing more dangerous than a lawyer playing with numbers, especially a lawyer that gets a PhD in some quant sort of field. Then all of a sudden they start using these numbers in a field that is fundamentally jurisprudential and normative. But there you go. And so there's all of this setup. So yeah, so the Roe reasoning, which is what Alito goes after for 30 pages, is eminently subject to attack, and rightly so. But that's the problem. the question isn't the Roe reasoning, and this is something that was made very clear by fairly conservative justices in the Casey decision in the 1990s. The issue isn't the rationale of 1970, whatever. The question is the result. And that result could be supported jurisprudentially. Alito avoids this, and he avoids this with a very neat trick, right? But you could have done that. And instead, he goes after the easy target, the sort of the quote unquote low hanging fruit. And that low hanging fruit was, well, the social science that they use and the rationale of Roe was just completely wrong. And, and there are all kinds of people who, to some extent, buy this. But that's not what should have been the center of the discussion. The center of the discussion should have been the result. And the means for supporting it should have been normative and jurisprudential, not based on this kind of 70s pop social science stuff that was fashionable at the time. And that's the pity. We'll see what the dissents do, and I suspect they don't get
so
it either.
Your point is, because that decision relied on social sciences instead of the normative, for the justification, instead of the normative jurisprudence that relying on that and then going back to that, we could have used those to actually lean on. We can't really do that anymore because those weren't used. Those rules, basically, right. Those processes weren't followed.
Right. And that's the really interesting part of Alito's opinion, and why this becomes a federalism case rather than a constitutional case, because the conservatives are as weak in jurisprudence, again, because they're creatures of American legal education from the 60s, 70s, 80s, and 90s, which another podcast I find to be a horrifically enormous catastrophic failure, because it produces this in the form of people who purport to serve the nation and in the role of judges at the highest court. But a horrible failure of legal education. The traditionalists are as incapable of the kind of jurisprudential analysis that was at the heart of the development of our foundational jurisprudence in the early 19th century as the liberals, the quote unquote liberals or progressives in this case. I hate using those terms, but that's what everyone uses.
Well, I mean, how else are you going to define the groups that are?
Right. And because they're incapable of doing it, they do two things. One, we've already talked about in the last podcast, which was the turn to federalism. Right. We can't do it. Let's leave it to the states. Well, how are the states going to do this? They're not going to be able to rely on science. They've just mocked it for 30 pages. They're going to have to rely on something else, which is probably some kind of normative value, who we are as a nation or as a people, by reference to normative baselines written into their constitution, and probably the federal constitution as well. So that was part one. But the other thing they did, which they've used to some really good effect in the development of modern religion clause jurisprudence, is that they relied on a so-called history and tradition test. And yes, the history and tradition test, that unless there is a history and tradition for the embrace of a particular thing, unless this is something, for example, that we can look that existed in 1791 and or from 1791 on has a long and quite in your face kind of historical significance in the way in which at least the official institutions of the Americans believe, which is another problem with the historical test. We'll get to that in a second. That in the unable to show that there is a history tradition of abortion rights, that there is no way that you could read abortion rights into a constitution that was written in 1791 or into the 14th Amendment that was written in the 1860s, right? And so they've used this in a number of cases. In the context of the religion clauses, they use it to support the embedding of religion, religious institutions, and religious practices within the practices and operations of the state and the state apparatus. In this case, they use the same kind of theory to show that there is no history and tradition of a right to abortion. But again, they're being very selective.
Right. So
right.
We like to suppress ladies. We have a history and tradition, time-honored tradition of suppressing the ladies.
Right, but but here's the thing, and I'll give you an example. When people talk about the lack of gender equality, or the idea that in this country, it was clear that before the 20th century, no one believed in equal rights for women, the people that they normally quote are men.
Oh, yeah.
Right. No one talks about Abigail Adams. No one talks about the women who, no doubt, in the 18th and 19th century, likely had a very different view, but their view apparently didn't count for counting whether there was this robust sense. And the same thing here applies to abortion rights. Yes, everyone who is talking were either people who were given space within the public discourse. Why? Because they were saying things that those in
that they liked.
Public discourse, right? Or because they were
mons. They were man.
There you go.
And look at all the men talking about all this stuff they know so much about.
The argument is against specious. The argument is against again not specious in the sense that it's wrong, but specious in the sense that it is incomplete. And if it were incomplete, then the history and tradition would be far more ambiguous and ought to be more worrisome in the course of doing what these 5 justices are purporting to do.
I mean, it's kind of disgusting because, I mean, what he's saying right now is like, hey, let's look back at the Griswold versus Connecticut, founding, like when it was found unconstitutional to or no, before that, like when contraception and abortion were offering any information regarding contraception and abortion, like in the Comstock laws, like that we weren't allowed to do that.
Right.
But so there's a long history of that until 1965 when we had the Griswold versus Connecticut. So that was the only time that. And so why did we do it then? Why did we overturn? Why was it okay then?
Oh, well, again, remember that was a case involving, I believe that was a married couple, and in a sense, with the majority here, the purported majority, assuming that they hold together, again, all these caveats, is that in fact you're comparing apples and oranges. That when you're talking about Griswold, you're talking about something that is so different from what we're talking about here, that really the case may have very little application. And they tend to read those cases very conservatively. But again, it's not implausible, their readings of those cases. It's just that they tend to read it in a way that isn't necessarily the only way in which you can read it. Now, having said that, I want to keep us where we are, which is the result in Roe, that is women's autonomy. And that for me is the most striking failure of the decision, hiding behind federalism, a jurisprudence, a kind of reactive jurisprudence and late to the ball game jurisprudence of federalism, and hiding behind very narrow readings of and distinctions of the other cases. We never get, what the court is able to avoid the much harder case about women's autonomy as women, and therefore as beings that are different from men in one critical respect. I'm sure in many other critical
What do you mean?
In one critical respect.
Is this like kindergarten cop style? Boys have a
right. Boys have a that, and girls have a that. Right. But that is really something that is quite worthy of discussion within the constitutional framework, in the same way that we worry about the autonomy of persons irrespective of their ethnicity, right? Irrespective of their national origins, irrespective increasingly of their abilities or of their, we don't say disabilities anymore, we say their abilities, right? The differential nature.
I was going to let you struggle there for a minute. I'm sorry.
The vocabulary is changing, and probably all this vocabulary is going to be obsolete in a short period.
Oh yeah.
But and it really is a pity. And so what they, in a sense, what they did was they said, well, we don't like we certainly hate the reasoning in Roe, and therefore we hate Casey's justification. We hate the result in Roe, and therefore we really hate Casey. Why did they go ahead and do that? And they did it on the thinnest of reeds, which was the stare decisis, that is the binding nature of precedent, which we talked about in our last podcast. I said, but having done that, then having gotten rid of both, we're not going to give you a substitute. We're actually not going to have the conversation that we should be having that led us to, and their justification is, well, that's really not for us to do.
Right. It seems like the Supreme Court for the last few years has just really deflected all of the really important decisions off to the states. We don't really want to deal with it.
But part of me, look, part of me I'm distressed, but part of me is not distressed. Everyone loves it when the Supreme Court does this, when the result is one that
for them.
Their belief. But you really want these 9 people with whom you have very little in common, and in whom you have to really trust that they can get out of their own personal weirdnesses, biases, worldviews, and the like, and that they become wholly invested in the principles, cultures, and the like of American jurisprudence, to then make these profoundly political and political generative decisions for the nation.
Well, now, according to Alito's opinion, it doesn't really matter what they say.
Yes, and that's the funny, right? So they've now not only crashed this, so we're not going to talk about the fundamental issue, which we should be talking about, but in any case, and you hit it on the head, it doesn't matter anymore since we've demolished stare decisis and the value of our precedent.
I don't really care about precedents anymore, so.
Which means if this holds, where is it that you should be having these conversations about women's autonomy? In the church, in the churches, in business, in social groups.
This is exactly what I was saying to sister earlier. I was like, well, it looks like we're going to have to be relying on our employers for social protections a little bit more.
And again, this goes back to my point. The minute you have to rely on someone, you've lost. Women are going to have to develop modalities of empowerment that makes it less critical for them to rely on.
Right.
Husband.
We need to get independent.
You need to be autonomous in solidarity with everyone whom you love, but you need to do, and that now the conversation is now just not in the political branches, but in order for, I think, for anyone who really has a strong sense of the value of autonomy, it really has to go not just within, but given the nature of our political culture, well beyond the four corners of the representative government, because this really isn't a question about relying on representative government as our new parent, but on relying on our ability to construct and maintain what we believe to be social and other institutional arrangements and beliefs and understandings that accord with our own sense of the way things ought to work, or that provide us with a space in which we can act on those, even if other people have different views. This is a very, very different way of looking at it. And in part, I mean, part of me really wonders whether we have, to some extent, and this is a critique that I've had for a number of years, and I'm not the only one. There are a number of people who've been worrying about this. But while the going was good, everyone said, well, yeah, we'll worry about it later because the decisions are going my way, so I'm not going to really rock the boat, which was dumb in the long run, but smart in the short run. And that is, do you really want to develop a society in this country that is wholly dependent on a master, a husband, a father, an administrative agency, a state, a representative?
You're trying to make me mad.
A boss.
You are. You're trying to push my buttons. That is
I am trying to push your buttons. These are hard questions, though. These are hard questions because I'm not suggesting anarchy, but I am suggesting the dangers of ceding control.
Yes.
To someone else, and to what ends, and that goes back, then that takes us to the ultimate question. In this country, with our political culture, what is or ought to be the role and limits of the state? How much power do you really want to give it? And how much power do you want to give any institutional body or any social body or collective body over you? And to some extent, what winds up happening is that potentially what this suggests is the need to develop systems of interlocking and blocking organizations that each limit each other's power, each must be accountable in some ways, but having enough of them around, each of them protected, so that the individual can move from one to the other or from many to another many, and in that process protect their own autonomy.
You're talking about a system of very complicated private checks and balances.
Right. And one that I suspect in a mature social order is absolutely necessary, given the nature of the 1,200-year development of our own culture as it's currently expressed here. It's a very different conversation in China, very different conversation in Eastern Europe, very different conversation in South Asia, very different conversation elsewhere. Maybe going to the same ends, but different conversation. All right, so we got like 5 minutes. I just want to touch one last little thing. The leak.
Okay.
Okay.
It's not good. I mean, it's not a good thing that was.
Certainly not without adult diapers.
Yeah, I mean,
all over the place.
It's gonna smell.
And you're gonna be embarrassed.
It's not a good look. It's not a good look.
It's not a good look. Yeah, no, it's a problem. We've got an opinion that undermines the court. We've got a bunch of politicians on the hard left and the hard right that have made it their life's goal to undermine the court. We've got the court shooting itself in the foot left and right. This reminds me, I mentioned this to someone else, to that horribly notorious decision in 1857, the Dred Scott case.
Oh.
It took the court almost a generation to regain its legitimacy. But you've got all of this going on, and then at the same time, the court begins to look like the other institutions. That is, it's one that is itself now showing flaws,
Yes.
institutional flaws, and that is not, that is very dangerous. Yeah, they're going to do their investigation. They'll probably find the person who's responsible. They'll probably find someone who's responsible. They're going to have to find, the usual.
They're going to have to find a scapegoat.
Well, that's cynical. They're going to have to find someone who's connected with this in some way. I'm trying to give them the benefit of the doubt. And then people will just go on and do some kind of weird psychocultural analysis of what motivated this person to do this. And that'll entertain people for a while. And that's sort of interesting. But what's more interesting is the damage that it's going to do to the integrity of the court.
Some people think that it was a good thing just because of transparency, but I think a lot is lost in that because, I mean, it was going to come out eventually. What's not good about this is that is the fallout afterwards. It's just
courts are not legislatures.
Yeah, exactly. This is not a political arena. It shouldn't be.
Right. The transparency and engagement in decision making that is absolutely necessary in administrative actions in legislature or in the executive is completely inimical to what is going on in a judicial body. You can test the decision, you can challenge it afterwards, but the process of decision making is not an auction, a political, or shouldn't be. At least in our tradition, and maybe it's going to change. So all kinds of things are now in the air. All kinds of balls are in the air, and that's sort of what we've been discussing over these two podcasts. And I apologize for just going on and on and on about this, but this is like you said, for a lawyer, it's a very energizing moment in a way.
It's a big deal.
And of course, what we'll discover a month from now is that we were completely and totally wrong in every possible way.
Yeah, but it was fun while it lasted. Or not.
Woof, woof.
Bark, bark. Thank you all for listening to our two-parter. We appreciate it. If you have any suggestions, complaints, if you have complaints, we don't want to hear it, but you can send them to us anyway. parallelbarkingpodcast@gmail.com. We appreciate it. Be well.
Woof, woof.
Bark, bark.